Good afternoon. My name is Jack Weston, and as you can see from the title of this webinar, my presentation to you today concerns property owner and manager liability for the independent criminal acts of third parties on the premises. This presentation is designed to dovetail with the other premises liability webinars presented over the past several weeks by our firm. At the outset, one needs to define what constitutes an independent criminal act. Simply put, these are the unforeseeable acts of third parties committed against invitees on the premises. The third party can be a tenant, a visitor, or even a trespasser. If, however, an employee of the property owner or manager commits the acts, other considerations may arise which are outside the scope of my presentation today. I believe it would be prudent to initially review the respective duties owed to the various types of individuals found on the property. There were really three categories of people coming on property. They are, in order from most to least duty owed, invitees, licensees, and trespassers. Invitees are those entering upon the premises at the express or implied invitation of the owner. They're either members of the public entering for a purpose for which the land is held open, or entering for a purpose connected with the business or other interests of the landowner or occupier. Invitees can include business customers, visitors, and guests. It's important to note that in Michigan, visitors to or tenants of an apartment complex are considered invitees and not licensees. This is because Michigan courts have determined that part of the rent paid to the landlord or landowner is consideration for giving to tenants the right to invite others onto the property. This distinction is clearly set forth in a number of Michigan cases, most notably Stanley versus Town Square Cooperative, which I shall discuss in more detail shortly. Generally, as regards invitees, and as set forth by the Michigan Supreme Court back in 1984 in Bertrand v. Allen Ford, the landowner has a duty to inspect, warn, and protect or make safe from the unreasonable risk of harm caused by a dangerous condition they know or should have known invitees would not discover, realize, or protect themselves against. However, in the context of third-party crime, as you will note when I discuss the progression of case law on that issue, this duty has been significantly modified, especially as it pertains to whether these types of acts are to be considered foreseeable or not. The second category of individuals entering on the land are licensees. Licensees are generally social guests, but could include anyone entering the landowner's property for the licensee's own purpose or business, with either the express or implied permission of the landowner. As noted previously, while one would ordinarily think that a guest of a tenant in an apartment complex who is a social guest entering the property for his or her own purpose, for example to visit the tenant, would therefore be a licensee. Michigan case law, as I noted, has modified their standing and regards them as invitees and not licensees. The duties owed licensees are somewhat diminished from those owed invitees. Generally, while the landowner does have a duty to warn licensees of known, dangerous, or concealed conditions, the landlord has no duty to inspect the property for these defects or to repair them. The third category of persons entering on land are trespassers. A trespasser is one who comes on the land without either an invitation or privilege to do so. There is no duty of care owed to a basic trespasser suing for negligence because the trespass is unforeseeable. Furthermore, the landowner has no duty to inspect the property for the presence of trespassers. There are subcategories of trespassers such as known, discovered, anticipated, and infant trespassers where the duty is somewhat modified. However, that is outside the scope of my presentation today. Can a duty be statutorily modified? The short answer is yes. It is possible to statutorily modify the duties owed to those who enter on the land because the legislature is freely empowered to modify duties by statute. Some confusion arises, however, concerning ordinances. Ordinances, as opposed to statutes, create no duty whatsoever. This has been long held by the Michigan Court of Appeals as exemplified by Johnson v. Davis, a 1986 case, and Ward v. Frank's Nursery and Crafts, Inc., a 1990 case. There is a caveat, however, under the Landlord-Tenant Act, which is Michigan Compiled Law Section 554.139, which is often called the Woodbury exception after the case Woodbury v. Bruckner. This case stands for the proposition that if properly pled by a plaintiff who is a tenant, the landlord loses the open and obvious defense where the plaintiff has pled a breach of duty to repair under the Landlord-Tenant Act. This, however, only applies to tenants and has not been extended to invitees such as guests. As you may have discerned from my discussion of duty, the foreseeability of the risk plays a pivotal role in establishing a duty. As you will see, this distinction is even more important in the realm of third-party crime. I will now move to a discussion of the evolution of landowner duty in the courts as relates to the independent criminal acts of third parties. The historical treatment of landowners goes back to 1975 in a case Samson v. Saginaw Professional Building Incorporated. In Samson, an employee of a tenant of an office building brought an action against the landlord of the building for injuries sustained by her when she was attacked in the building elevator by a mental patient who was receiving medical treatment at an entity that was another tenant in the building. A judgment was entered on a jury verdict for the employee and the landlord appealed. The verdict was upheld by the Court of Appeals and a leave to appeal to the Michigan Supreme Court was granted. During discovery, it was revealed that the landlord had received numerous inquiries from other tenants in the building regarding the fact that up to 25 mental patients per day would visit the clinic, which included patients from the Traverse City State Hospital and from the Ionia State Prison. The court considered that because other tenants in the building has voiced their concern over the use of the elevators and stairwells by mental patients to the landlord, the possibility of one of the patients committing a criminal act was foreseeable, at least to the tenants. In its defense, the defendant argued that an incident such as this had never occurred in the building. The testimony was supported by testimony from the director of the clinic, who testified that this was the first incident of this type that he was aware of in the history of the program. The court, however, chose to ignore defendant's notice argument, indicating it believed that the reasonableness of the risk involved was the more directed argument and not whether it was foreseeable or not. The court ruled further that the existence of the relationship between the landlord and its tenants and invitees placed the duty upon the landlord to protect those tenants and invitees from an unreasonable risk of physical harm. Furthermore, the court ruled that the type of incident giving rise to this claim was foreseeable to the landlord and that the court believed the magnitude of risk to be substantial. In sum, the court ruled that whether the landlord exercised reasonable care under the circumstances of this case was a question for the jury, and it further found no error in admitting testimony that the mental patient who had attacked and stabbed the plaintiff had stabbed another individual on a previous occasion. The court also found that it was the responsibility of the landlord to ensure that the common areas of the building were kept reasonably safe for the use of tenants and invitees. So, under Samson, the court held that the landlord had specific affirmative duties to protect its invitees and tenants. Further, the court believed that third-party criminal activities could be foreseeable. In Eisner v. Lafayette Towers, a 1983 case, it followed Samson and involved an action brought against the landlord of a building by an invitee who was robbed and sexually assaulted in the building's parking lot. The landlord was granted summary disposition and plaintiff appealed. The Court of Appeals, following the holding of Samson, held that a landlord owes a duty to its tenants to protect them from unreasonable risks of harm resulting from the foreseeable criminal activities of third parties within the common areas of the premises. In this case, the Court of Appeals indicated that its review of the evidence provided, both in support and opposition to the appeal, left numerous unanswered questions whether, under the circumstances of this case, the landlord might have had a duty to take some sort of protective action regarding invitees, as well as whether the type of injury such as that suffered by plaintiff was foreseeable. The court therefore reversed the summary judgment entered by the trial court and remanded the case. There is no record, however, showing that the case was ever resubmitted for appeal, so it likely settled after the remand. The significance of this case is that it affirms the belief held by the Supreme Court in Samson that the criminal acts of third parties might be foreseeable. In Williams v. Cunningham drugstores, plaintiff was a business invitee shopping at defendant's drugstore when an armed robbery took place. For some unknown reason, during the ensuing confusion, plaintiff followed the robber out of the store and the robber turned and shot him. Williams filed a complaint against the store alleging that it had breached its duty to exercise reasonable care for plaintiff's safety. Specifically, Williams alleged that defendant had failed to provide armed, visible security guards. At the close of plaintiff's proofs, defendant moved for a directed verdict based upon the fact that defendant did not have a duty to protect invitees from the unforeseeable acts of third parties. The motion was granted and plaintiff appealed. The Court of Appeals affirmed the decision of the trial court, holding that, as a matter of law, defendant's duty of reasonable care did not extend providing the degree of protection that plaintiff claimed was required. The Michigan Supreme Court granted plaintiff leave to appeal and affirmed that, as a matter of law, while a merchant does owe a duty of reasonable care to its invitees, this duty does not extend to providing armed, visible security guards to protect customers from the criminal acts of third parties. The rationale of the court was based upon public policy concerns, in that it should not be expected that merchants should have to assume the responsibility of providing police protection on their premises. The significance of this holding is that it signals a shift by the Michigan Supreme Court in limiting the duties of merchants to their invitees, and while the court limited its holding to security guards, it hinted that merchants should not be expected to assume police powers. In Holland v. Lidl, a 1993 case which followed Williams, involved an action brought against the landlord by a tenant who was abducted from the apartment building's parking garage. Plaintiff alleged that while the parking garage had a card key entry system and surveillance cameras, the landlord failed to provide reasonable security for the tenants of the apartment complex, specifically that defendant failed to provide a security guard. Defendant moved for summary disposition, which was denied by the trial court, as was defendant's motion for directed verdict. Citing Williams, the court noted that landowners have an affirmative duty to protect their invitees while on the landowner's property. The court held, however, that the landowner is only obligated to use reasonable care for the protection of the invitee and should not be held to be the absolute insurer of the invitee's safety. The court noted, however, following the Eisner and Samson line of cases, that a landlord does have the duty to protect its tenants from the foreseeable criminal activities of third parties while the tenants are in the common areas of the landlord's premises. So, while the court somewhat watered down the duties owed to tenants by their landlord, it still indicated that third-party crime could not only be foreseeable, but that whether the third-party criminal activity would be foreseeable under the circumstances was a question of fact for the jury and could not be decided by the court as a matter of law. Finally, citing Williams, the court noted that the duty of reasonable care a merchant owes its customers does not extend to providing armed security guards. However, the court passed on deciding that the reasoning of Williams would also apply in landlord-tenant cases, as opposed to only merchant-invitee cases. Instead, it decided that, based upon conflicting facts and testimony surrounding the assault of Ms. Holland, issues of fact would have precluded the granting of a motion for summary disposition, as well as the motion for directed verdict. More disturbing in the holding, however, was the court's opinion that while the landlord may have no duty to provide a parking lot security guard, if it voluntarily assumed that duty, a cause of action could arguably exist if the landlord was then negligent in performing this assumed duty. In this case, evidence had surfaced that the landlord had at one time hired a security guard, but when the guard died, had substituted the surveillance cameras instead. Interestingly, the Court of Appeals cited its holding in Scott v. Harper Recreation in support of this theory. The Michigan Supreme Court, however, reversed the holding of the Court of Appeals in Scott that same year in the next case. In Scott v. Harper Recreation, Inc., 1993 case, an unidentified gunman shot plaintiff and defendant Harpo's parking lot. At issue in the case was the fact that the defendant nightclub had advertised that it had a lit and guarded parking lot. Plaintiff claimed that he relied upon the assertions of the landlord that the parking lot was secure as a basis for his patronage. Further, plaintiff alleged that because defendant had issued the advertisements regarding the secure parking lot, it had assumed the responsibility to provide a secure area for patrons. The circuit court granted summary disposition for defendant and plaintiff appealed. The Court of Appeals reversed following its line of reasoning set forth in Holland and remanded the case, basing its opinion on the fact that By virtue of advertising a safe and secure parking lot, defendant had assumed a duty that it would not ordinarily have had, and that this therefore created issues of fact that would preclude granting a motion for summary disposition. Defendant appealed this ruling, and the Michigan Supreme Court reversed the Court of Appeals, basing its ruling in part on its holding in Williams. The court noted that, in this case, plaintiffs sought to avoid the rule of Williams by relying on the principle that the person who voluntarily undertakes a responsibility can be held liable if the responsibility undertaken is performed negligently. The court specifically held that it rejected the notion that a merchant who makes its property visibly safer has increased the risk of harm by causing people to be less anxious. It also held that by virtue of the fact that merchants are not ordinarily responsible for the criminal acts of third parties, liability may not be imposed on a merchant who, in a good faith effort to prevent crime, fails to prevent all crime. Nor may suit be brought on the theory that the safety measures taken are less effective than they could or should have been. This holding signals an easing of the expectations as regards property owners, at least as far as merchants are concerned. In Stanley versus Town Square Cooperative, an invitee brought an action against the property management company when she was robbed and assaulted in the parking lot of the complex. Plaintiff alleged that the management company and apartment cooperative association had breached their duty to keep the common areas of the cooperative reasonably safe. Defendant filed a motion for summary disposition, which was granted by the trial court. Plaintiff appealed, and the Court of Appeals affirmed the holding of the trial court. Court of Appeals held that the landlord did have a duty to protect its tenants and their guests from foreseeable criminal activities in common areas on the premises because the landlord possessed exclusive control over these common areas. The court further held that while the landlord also has a duty to take reasonable measures to protect its invitees from conditions on the land created by the landlord which present an unusual risk of criminal attack, the landlord did not have a duty to make its premises safer than the surrounding community. Again, while still imposing some duty based upon the belief that at least some crime is foreseeable, the court was beginning to chip away at the amount and type of duty owed. In Mason versus Royal DeQuinder Incorporated, a 1997 case, plaintiff and three friends were patrons at a bar. One of plaintiff's friends got into an altercation with an individual with whom he was familiar. Employees of the bar broke the fight up and ejected the person who had attacked plaintiff's friend, instructing the others to wait inside until the attacking individual had left the premises. At a later point, plaintiff emerged into the parking lot where he was confronted by his friend's assailant, who then assaulted plaintiff. Plaintiff sued the bar on both dram shop and premises liability theories. At the close of plaintiff's proofs, the trial court granted defendant's motion for directed verdict on the dram shop claim, but denied the motion on the premises liability claim. Defendant appealed, and the Court of Appeals reversed, citing both Williams and Scott. Specifically, the Court of Appeals held that while landowners do have a special relationship with invitees, they are not the total or complete insurers of their invitees' safety and do not have a duty to protect invitees from unforeseeable, unreasonable risks. However, the court also held that it believed that merchants did have a duty to use reasonable care to protect identifiable invitees from the foreseeable criminal acts of third parties, and further that they must use reasonable measures to do so. While the court did not find that defendant in this specific case had a duty to take reasonable measures to protect plaintiff, this holding obviously raised the bar for landowners regarding the criminal acts of third parties. This holding, however, was to be short-lived. In Kraft versus TriCounty Security, a case handled by our firm, plaintiff was shot and killed in defendant's parking lot after he had parked in an area where a security company employee employed by the venue had directed him to park. Plaintiff sued both the landlord and the security company. However, because the landlord was in bankruptcy, that portion of the litigation was stayed. The security company filed a motion for summary disposition seeking to strike plaintiff's claims that defendants failed to properly protect plaintiff or to control the premises. The court granted the motion, finding that the security company owed no duty to plaintiff to protect him from the criminal acts of third parties. Plaintiff appealed, and the Court of Appeals, following the line of cases stemming from Williams, likened this matter to the Scott case discussed previously, where the plaintiff had attempted to avoid the holding in Williams that merchants are not ordinarily responsible for the criminal acts of third parties simply by alleging the landowner or merchant had assumed a duty and negligently performed it. Accordingly, the Court of Appeals affirmed the holding of the trial court and the case was dismissed. In McDonald versus PKT, Pine Knob Theater, a significant Supreme Court case handled both at the trial and appellate levels by our firm, a spectator at a concert held at Pine Knob Theater brought suit against the owner of the property for injuries allegedly received during a sod throwing incident at the venue. Plaintiff filed suit alleging that defendant was negligent in failing to provide proper security to protect her from the type of injury she suffered. Defendant moved for summary disposition, arguing that it did not have a duty to protect invitees from the criminal acts of third parties. The trial court granted defendant's motion and plaintiff appealed. The Court of Appeals reversed the trial court, holding that it believed there were issues of fact as to whether the sod throwing incident created a foreseeable risk of harm, and further whether the security measures taken by defendant were reasonable under the circumstances. Defendant then appealed, and the Michigan Supreme Court granted the application. In an opinion that overruled its prior holding in Mason versus Royal DeQuinder, which I discussed a moment ago, the court held, quote, subjecting a merchant to liability solely on the basis of a foreseeability analysis is misbegotten. Because criminal activity is irrational and unpredictable, it is in this sense invariably foreseeable everywhere. However, even police who are specially trained and equipped to anticipate and deal with crime are unfortunately unable to universally prevent it. This is a testament to the arbitrary nature of crime. Given these realities, it is unjustifiable to make merchants, who not only have much less experience than the police in dealing with criminal activity, but who are also without a community deputation to do so, effectively vicarious liable for the criminal acts of third parties. Close quote. Based upon this analysis, the court held that a merchant has no general obligation to anticipate and prevent criminal acts against invitees, and its only duty to respond is to make reasonable efforts to contact the police. In support of this, the court relied upon its prior holdings in Williams and Scott. Significantly, in overruling Mason versus Royal DeQuinder, the court held that it is only present activity on the premises and not any past incidents that create a duty to respond to the risk of imminent harm to invitees by the criminal acts of third parties. In essence, the court held that because of the irrational and unforeseeable nature of third-party crime, simply because criminal acts had occurred on the premises previously does not give rise to notice of potential future criminal acts. This holding severely gutted the significant duties previously owed by merchants to the invitees in cases such as Samson, because it essentially held that crime by its nature was not generally considered foreseeable, and no duty could therefore arise. Under this case, the only duty of a merchant is to reasonably summon the police when given notice that crime has occurred. Intresting versus Occidental Development, a case which I personally handled, involved a woman who was assaulted and robbed in the parking lot of an apartment building where she had gone to visit her boyfriend who lived there. Plaintiff argued that McDonald and the prior cases concerning the duties owed invitees relating to third-party crime applied only to merchants and not to other types of landowners, such as landlords. Our argument was that while it was true that in most of the prior cases defendants had been merchants of one sort or another, for example a drugstore, a concert venue, a club, or a bar, those cases had also discussed duties owed by landowners, albeit in more general terms. We additionally argued that a comparison of the duties owed invitees by landowners versus those owed by merchants found them to be identical. We argued, therefore, that McDonald should equally apply to property owners in general, no matter what their status. The trial court agreed, granting our motion for summary disposition. Plaintiff appealed to the Michigan Court of Appeals, but the Court of Appeals upheld the trial court ruling in an unpublished opinion. In Ridley versus Thompson Towers Limited, which was yet another case handled by our firm, plaintiff, a tenant at defendant's premises, brought suit after she was beaten with a golf club in the lobby of the apartment building by her former boyfriend. Plaintiff had told the apartment complex that she did not wish for the boyfriend to be allowed in the building. Defendant's employees saw the boyfriend in the lobby and told him that plaintiff didn't want to see him anymore. Shortly after that exchange, plaintiff appeared in the lobby, whereupon her boyfriend began beating her with a golf club. Defendant's employee immediately called the police. Defendant filed a motion for summary disposition based upon no breach of duty, which the trial court denied. Defendant appealed. While the Court of Appeals reversed the trial court, it did so without addressing defendant's contention that the holding in McDonald would apply equally to landlords. Instead, the Court of Appeals focused solely on the particular facts of the case, holding that there was no proximate cause because the attack on plaintiff was unforeseeable to defendant, and defendant responded appropriately by promptly calling the police. In Graves v. Warner Brothers, a very public case, defendants, the Jenny Jones Talk Show, and Warner Brothers, the show's producer, appealed a judgment of almost $30 million entered in favor of plaintiff's personal representatives by the Oakland County Circuit Court. The personal representatives of plaintiff Scott Amador had brought an action against defendants after Amador was killed after being a guest on the Jenny Jones Talk Show. Amador had revealed on the show that he had a homosexual crush on the man who ultimately killed him. Defendant's motion for summary disposition on the issue of duty was denied by the trial court, and the jury found in favor of the personal representatives. The appellate court reversed and held that defendants did not owe a duty to the decedent. The appellate court noted that in general there is no legal duty obligating one person to aid or protect another. Moreover, an individual had no duty to protect another from the criminal acts of a third party in the absence of a special relationship between the defendant and the plaintiff, or the defendant and the third party. The appellate court held that there was no special relationship between defendants and Amador that warranted the imposition of a duty. Any relationship defendants had with the decedent by inviting him to be on the show ended when the decedent left the show. The judgment of the trial court was vacated, and the matter was remanded to the trial court with directions that it enter judgment in favor of defendants. The significance of this ruling is that it essentially held that duty is limited to reasonably responding to situations that occur on the premises and pose a risk of imminent and foreseeable harm to identifiable invitees, and the duty to respond is limited only to contacting the police. This duty does not continue after the merchant-invitee relationship ends. Benton v. Briggs held that the fact that a property owner-landlord had an allegedly defective exterior door on one of its apartments was not a foreseeable cause of the death of a tenant who was shot through that door while trying to hold it closed against an intruder. Based on the circumstances of the case, to include the fact that the decedent had opened the door and then tried to close it when he saw the intruder had a gun, there was insufficient evidence to show that had there been a more substantial door with a stronger lock, the tenant would not have been killed. In Smith v. Smith, an unpublished 2005 Court of Appeals opinion, the court held that the property owner landlord was not negligent in hiring an employee with a criminal history who subsequently killed a tenant during a personal sexual encounter because the killing took place outside of the employee's scheduled work hours. Furthermore, the court held that the sexual relationship between the employee and the decedent was clearly outside the course and scope of the employee's job, and the tragic outcome was therefore not a foreseeable consequence of any conduct by the property owner or landlord. In Zygo versus Hurley Medical Center, plaintiff sued Hurley Hospital, alleging that she was sexually assaulted by a hospital employee while she was in the emergency room suffering a manic depressive episode. Motions for summary disposition and a directed verdict were denied, and a jury awarded plaintiff over $1 million. The hospital appealed, and the Court of Appeals reversed, holding that the hospital should have been granted either summary disposition or a directed verdict. Specifically, the court held that under the doctrine of respondeat superior, the general rule is that an employer is not liable for the torts intentionally or recklessly committed by an employee when those torts are beyond the scope of the employee's business. Plaintiff appealed to the Michigan Supreme Court. The Michigan Supreme Court partially reversed the Court of Appeals, noting that it did not agree that there was an exception to the general lack of employer liability for cases where a plaintiff showed that he or she relied on the apparent authority of the employee, or that the employee was aided in harming the plaintiff by the existence of the agency relationship between the employee and the employer. The Supreme Court noted that such an exception would potentially subject employers to strict liability for the crimes of their employees. Because the court declined to adopt this exception, Plaintiff in this case failed to establish that the hospital was vicariously liable for the sexual misconduct of its employee, who was clearly not acting within the scope of his employment when he engaged in acts of sexual misconduct with the patient. Therefore, the generally recognized exception to the respondeat superior rule of employer liability found in 1 Restatement Agency 2, under which an employer would be liable for the torts of an employee acting outside the scope of his or her employment when the employee is aided in accomplishing the tort by the existence of the agency relation, has not been adopted in the state of Michigan. In Velez v. Dollar Tree Stores, the court held that Dollar Tree owed no duty to a customer assaulted by another customer except to make reasonable efforts to contact the police, even though Dollar Tree had its own security personnel in the store. In Lamar versus Ramada Franchise Systems, Inc., a fight between 2 guests in the hotel resulted in injury. Allegedly, the 2 combatants had argued earlier in the evening at one of the several parties that had been booked into the hotel. The 2 individuals later ran into each other when one of them was riding an elevator that stopped at a floor where the other one was waiting, and a fight ensued. The issue was whether, because of the earlier altercation between the 2, the hotel should have been on notice that authorities should have been summoned earlier. The Court of Appeals held that the reasonableness of defendants' efforts to contact the police should be decided by a jury and not the court. This case is distinguishable, however, because there was a factual dispute as to how long defendant had known the fight had been going on at the hotel before it called the police, which related to whether defendant's response to the fight was reasonable or not. As you can see by now, the reasonableness of the response to criminal activity is the critical factor in determining whether a merchant or landlord has any liability. In Brown v. Brown, plaintiff was a security guard employed by an independent security company who was contracted to work at defendant Samuel Whitter Steel. An employee of Samuel Whitter raped the security guard at the corporation's facility. The employee had no prior criminal record, no history of violent behavior, and no history indicating that he harbored a propensity to commit rape. However, the security guard alleged that the employee routinely made sexually explicit comments to her. At issue was whether the corporation's knowledge of such comments created a basis for holding the corporation liable for the rape. The case was dismissed by the trial court on motion based upon no liability for the independent criminal act. Plaintiff appealed, and the Court of Appeals reversed the dismissal, noting that an issue of fact existed whether Samuel Whitter, the employer, should have known of its employee's propensities. Samuel Whitter appealed to the Michigan Supreme Court, which reversed the appellate court and reinstated the trial court's dismissal. Specifically, the Supreme Court held that where an employee had no prior criminal record or history of violent behavior indicating a propensity to rape, the corporation, as the employer, was not liable solely on the basis of the employee's lewd comments for the rape perpetrated by that employee when those comments failed to convey an unmistakable, particularized threat of rape. Because the employee did not commit prior acts that would have put the corporation on notice of his propensity to commit rape, and his workplace speech was not predictive of his criminal act, the corporation could not be held liable. It should be noted, however, that if an employer does have knowledge of past acts of impropriety, violence, or disorder on the part of the employee, that knowledge is generally considered sufficient to potentially place the employer on notice of the employee's violent propensities. This is cited in a case, Hirsch v. Kentfield Builders, a 1971 Michigan Supreme Court case. The most recent ruling on independent criminal acts is the holding of the Court of Appeals in Bailey v. Schaff, a 2011 opinion. In this case, a resident of defendant's apartment complex, Laura Green, told 2 contract security guards employed by the complex, named Baker and Campbell, that there was a man on the premises with a gun. She told them that he was waving the gun and threatening to shoot the guests, and asserted later that she pointed to the area of the gathering and identified the man with the gun. Despite Green's warnings, Baker and Campbell chose not to investigate this situation. Instead, they chose to drive an unrelated, intoxicated resident back to his apartment. Approximately 10 or 15 minutes after they dropped off the intoxicated resident, Baker and Campbell heard 2 gunshots. They drove back to the gathering where they observed a man, later identified as Plaintiff Bailey, lying face down with 2 gunshot wounds in his upper back. Bailey suffered severe injuries, including a spinal cord injury and paraplegia. Bailey sued, alleging that defendants were liable for the shooting under theories of negligence, premises liability, and vicarious liability. The Genesee County Circuit Court dismissed plaintiff's claims against the owner and manager of the apartment complex on motion, and plaintiff appealed. The Court of Appeals held that the trial court did not err to the extent that it dismissed the claims premised on any duty of defendants to provide security or otherwise make the premises safe from criminal activity. However, it ruled that the trial court erred to the extent that it determined that plaintiff did not state a claim that defendants failed to respond properly through their agents to the imminent threat that the shooter posed. The court held that defendants had a duty to call the police once they had knowledge of an ongoing emergency that posed or foreseeable risk of imminent harm to an identifiable invitee or class of invitees. So they should have called the police the minute that they were told by the woman that the person was threatening people with the gun. A premises possessor has a duty to take reasonable measures in response to an ongoing situation that was occurring on the premises, which meant expediting the involvement or reasonably attempting to notify the police when they were given notice there was a man with a gun threatening harm to people on the property. The message here is that the landlord owes a duty to both tenants and their guests to take reasonable measures within a reasonable period of time in response to ongoing crime taking place on the premises. While this generally only means calling the police, and landlords and their agents are not expected to fight crime themselves, the response must be timely. This case is also important in reinforcing the fact that landlords are under no duty to provide security services for their properties, and if security services have been provided, it doesn't create a duty for those security services to prevent the crime. Note, however, that a landlord will be held responsible if the security service it has hired, who are considered contract employees, fail to timely notify police to an ongoing crime on the property. The bottom line is, as to what the landowner's duty is relating to criminal acts on the premises, is that the only duty of landowners and merchants in responding to independent criminal acts on the property common areas is to make reasonable efforts to timely contact the police. I won't be in my office the day this webinar is scheduled to be broadcast, but should anyone have any questions, they should feel free to contact me at either the telephone number or email address on the screen. Thank you.